Assalamu alaikum. My name is Bilal Sain Khan and I'm your host for the next hour on Just Law on Ikra TV. As our viewers are aware, Just Law deals with any aspect of criminal law, and for the next hour this is a live call show. I will be taking calls live from our viewers. There will be a number at the bottom of the screen, and I ask all our callers, do call in with any concerns or any issues that you may have, and on Just Law we can deal with any issue that you have, but predominantly I ask if there is any question regarding criminal matters, that you call in and ask any questions. It may be road traffic law, it may be on criminal cases, etc. And as our viewers will appreciate, because this is a live call show and because of the nature of your cases, your particular case details will not be able to be dwelled upon. I won't be able to look into paperwork, etc. And at times it'll be more appropriate for me to look into your paperwork in more detail in order to advise you accordingly with your specific case. However, on Just Law, what I'll try to do is give a generic advice regarding any question that you may have and try to answer the question. If there is any question regarding any other aspects of law that I cannot answer immediately, what I will do is take down the questions, write them down, make a note of them, and on the following week I will answer each and every question that you may have. Now you can contact the contact room and provide them with your details, with your telephone number, etc., and I will aim to get back to you within the next 2 or 3 days if there's any caller that doesn't want to go live on air, however has any pressing issue, concerns to discuss, then you can contact me and I will either email you or ring you back within the next couple of days. Now for our regular viewers, on the last show a sister called in and she mentioned an issue that she has regarding a child that was arrested, and it was decided last week that I will spend best part of today's show discussing the rights and entitlements of a person inside custody, and also explain in detail the police caution and advise you what you should do if you've been cautioned for an offence. Now, I went into some detail last week regarding your rights and entitlements whilst at a police station. Now, the fundamental rights are: number one, to notify someone that you have been arrested. Number two is in order to consult with the codes of practice, which is a book that governs the police, their roles and responsibilities, the way that they deal with you. Thirdly is the right to consult a solicitor specializing in criminal law, and that's all free of charge. And fourthly, and this is quite important, is if you do not understand English, you are entitled to have a interpreter present throughout the police interview, and also if there's any concerns, then it's your right to consult with an interpreter throughout your time whilst in custody. Now that brings us on to the question: if you are ever questioned or suspected of an offence, whatever it may be, whether it's a minor offence, whether it's a serious offence, the police at the stage that you are suspected of something and they want to speak to you and gather evidence by questioning, then you have to be cautioned. Now, some of our viewers may have heard the caution on other shows, on television, or on other programs. Now, it's quite important that everyone understands the caution. It's the basis of any criminal case against you. The police always have to caution you. Now, if they're even asking you questions by way of letter, you'll always see the caution written. And if you're stopped at a roadside, the police will always caution you at a stage where they believe that you're suspected of being involved in an offence, such as going through red traffic light, such as driving without insurance, inappropriate insurance, or a more serious criminal offence such as an assault, etc. And the list goes on. Now, what is this caution? The caution says this: you do not have to say anything, but it may harm your defence if you do not mention, when questioned, something you later rely upon in court, and anything you do say may be given in evidence. Now, it may sound like a mouthful, however, that caution can be broken down into 3 different parts. The first part is the fundamental right, which is you do not have to say anything. It's your right in English law just to remain quiet. You don't have to say anything. You don't have to assist the police. You don't have to talk to the police. Sometimes people think, oh, it's quite rude of me not to speak to the police. But once you've been given the caution, and then at that stage you're well within your right to stay quiet. You don't even have to say nothing. You can remain totally silent. You can say to them, I want to consult with a solicitor, and it's your right. So the first part is you do not have to say anything, which is self-explanatory. Our viewers may be aware that in England and Wales, the law is that the prosecution, or if you would like, the police, have to prove a case against you beyond reasonable doubt. That's for them to make another person, be it a judge, a district judge, magistrates, a jury, sure of your involvement in that offence. It's not for you as a defendant, as a suspect, to prove your innocence. Now, you don't have to provide any evidence whatsoever. It's for the police to prove your guilt. And that's very important to know and to understand, because that's the foundation of anything or any prosecution, for you to know that you don't have to say anything. There is the caveat, and the caveat is the middle part of the caution, and that says, however, it may harm your defence if you do not mention, when questioned, something you later rely upon in court. Now, what that middle part is saying is, yes, although you have the right to remain silent and you have the right to not say nothing, and because the police, the prosecution have to prove that case against you, if you do have a defence and you don't mention it, and then this case goes to court, and then you mention something that was quite easy for you to mention at the time, then the court will be less likely to believe you. Doesn't mean that they won't believe you. Doesn't mean that they will believe you. It just means that the term used in law is an adverse inference will be drawn, and the inference is, oh, you've had time to make up this story. If you was innocent, if you had nothing to hide, you would have said this immediately. Let's use an example for that. So let's say that I'm being accused of going through a red light in Bradford City Centre at 6 o'clock today. Now, as the viewers are aware, I'm on ICRA TV at 6 o'clock today, and it's quite easy for me to say, wait a minute, officer, it wasn't me, because I've got an alibi. The alibi is that I was on live TV. You can have a look at the show, you can speak to the viewers, you can speak to the organisers, and then it's quite easy for me to say it. Now, if I remain quiet and don't mention nothing, if the case goes to court, the court can say, Mr. Khan, it was quite easy for you to just tell the police at that time that he wasn't there. The obvious answer is, yep, but the caution says I don't have to say nothing. That's the reason I didn't say it. However, it's something that has to be judged carefully, whether or not you talk, whether you don't talk, and each individual circumstances and individual case is looked upon its own merit. Whilst sometimes it's good for you to say nothing or don't say anything, and then at other times it's a wrong decision. You should really be talking. Like the example that I've just given for me committing a road traffic offence at the time that I'm before the live viewers, is quite easy, and therefore if I don't mention that, an adverse inference may be drawn afterwards as to why I didn't provide that information. Now the last part of the caution is anything you do say may be given in evidence. Now that can be for you or against you, because what the officers will do is either record the notes that you make. If it's at a roadside, nowadays officers have a body-worn camera, and the camera will be switched on upon any interactions with a possible suspect, and then once they've read the caution to you, that can be tendered as evidence either for you or against you at a later date. Now we know that the caution is said on numerous occasions. Let's say for argument's sake you were stopped at the roadside and you're suspected of committing an arrestable offence. Now you will be cautioned at the roadside. You will then be taken to the police custody, at which stage a police sergeant will book you into custody, take you through your rights again, notify you of your entitlements, check on your welfare, make sure that you're okay, there's no health issues that need addressing, and then upon doing that procedure you'll be cautioned on a second occasion, and the caution will be read out to you. And it's important for everyone to know that all conversations in a police custody are recorded, both visually and audio. There's a visual and audio recording within the police station, throughout the police station. So when the custody sergeant mentions a caution to you on the second occasion, what will happen is all of your interactions will be recorded, but the custody sergeant will also be typing onto your custody record, which is a document that has all your interactions written on it from the minute that you're booked into custody up until the time that you exit custody. Each and every log will be on there, and the custody sergeant will say, I cautioned him, and his reply to caution was XYZ, and then it'll be written down. Now the third time that you'll be given the caution is just prior to the interview. So what will happen is at the commencement of the interview you'll be given your rights entitlements again, introductions will be gone through, and then the caution will be read out again. And then at that stage officers will be taking notes. However, a recording device within the room, be it a CD recorder, be it cassette recorders, depending on which police station you are. Some old school still use cassettes, some use DVDs, and the majority now use hard drives in which the interview is recorded. So all that can be used as a note of what actually went on in the interview and what information was given, whether or not you answered questions, whether or not you did not answer questions, and more importantly at a later date, whether or not an adverse inference will be drawn into your silence. Or even, for argument's sake, let's say you provided an account to the police initially. You told them a certain story, you told them this is the position, and thereafter it transpired that you said something else. Then an adverse inference once again will be drawn as to, wait a minute, you was questioned regarding this, and all these questions were asked of you, and at that stage you said this, and now you're changing that account, you're saying something else. So which one are we going to believe? Are we going to believe this or that? And then if you say, no, I never said that, the recordings, etc., will be shown to you. Now, on that topic, quite often we find ourselves in a position where you've made a comment to the police, and the police are duty bound to write down that comment in what's called a pocket notebook entry. All officers will have a book on them, and on that book they write down their interactions with people, and any significant statements that you make or any reply to caution that you make will be written in the pocket notebook entry, and then you will be invited to sign that to say whether you agree or disagree. Now, once again, insofar as signing any documents are concerned, it's your right in law to say, I'm not signing this document, I don't want to sign it, and the reason could be, I want legal advice, I want to speak to a solicitor, I want to ask them whether or not I should sign this or not. Remember, you cannot be forced to do anything, and it's your right to consult with the solicitor, and the officers will say, yep, that's fine, you can speak to your solicitor, and then they'll invite you to sign the notebook at a later date during the interview, or they'll either write on there and endorse that the suspect declined to sign, and then they'll look for other ways in which the conversation can be adduced. Now, my understanding is there is a call, and we'll just go to the call. Assalamu alaikum, caller. Assalamu alaikum.
Walaikum salam. Can you hear me?
I can hear you.
Okay. भाई साहब, मैं टैक्सी ड्राइवर हूँ
जी,
और मेरा एक्सीडेंट हुआ है पहली बार
जी,
तो अभी मेरे पास पासपोर्ट भी पाकिस्तान की है
जी,
ठीक है। तो अभी मैं इंडेफिनिट के लिए अप्लाई होने वाला हूँ, और वो क्रिमिनल में कहलाता है वो?
तो एक्सीडेंट हुआ था आपका?
जी।
एक्सीडेंट तो प्रोसिक्यूशन कोई हुई थी जैसे
जी, वो कोर्ट में हियरिंग भी है मेरी।
जी, तो देखिए, दो बातें हैं ना, तो एक क्रिमिनल की केस हो सकता है या एक काउंटी कोर्ट हो सकता है उस क्लेम का। तो आपको पुलिस ने या कोर्ट किस वजह से, या पुलिस ने आपको सुमन्स किया है कोर्ट के लिए?
जी, पुलिस ने किया है।
जी, तो ऑफेंस क्या है?
वो फास्ट ड्राइव कर रहा था और एक्सीडेंट करा, हिट एंड रन।
Or hit and run. So failing to stop, they're failing to report an accident.
ये एक्सीडेंट भी हुआ था जी।
जी, fail to stop, fail to report an accident, yeah.
ये
तो और कोई ऑफेंसेस हैं उसमें, जैसे नो इंश्योरेंस या ड्राइविंग विद
इंश्योरेंस तो है मेरे पास, पर एमओटी भी सारा कुछ है मेरे पास।
सिर्फ फेलिंग टू स्टॉप और फेलिंग टू रिपोर्ट एन एक्सीडेंट, ये सिर्फ है? ठीक है, ठीक है। तो फेलिंग टू स्टॉप एंड फेलिंग टू रिपोर्ट एन एक्सीडेंट, ये जो ऑफेंस है ना, ये इंडोर्सेबल ऑफेंस है। तो ये आपके ड्राइविंग लाइसेंस पर जो है ना पॉइंट हो जाएंगे, और ऑल्सो फाइनेंशियल पेनल्टी भी हो जाएगा। तो
क्रिमिनल क्राइम में नहीं आएगा ना ये? जी
जी, ये क्रिमिनल केस के अंदर आ जाएगा ना। तो ये आपको डिक्लेयर करना पड़ेगा जब आप अप्लाई करेंगे ना ब्रिटिश नेशनलिटी के लिए। तो डिपेंड है आपका रूट कौन सा रूट है, तो ये थोड़ा मुश्किल हो सकता है आपकी एप्लीकेशन में, तो आपको ये डिस्क्लोज़ करना पड़ेगा। तो अगर आप अपनी पर्टिकुलर केस के बारे में या मालूमात करना चाहते हैं ना, तो आप ऐसे करें कि कॉन्टैक्ट सेंटर फ़ोन करें, तो मेरा नंबर ले लें, तो फिर जो है ना मैं एग्जैक्टली आपकी ऑफेंसेस के बारे में, तो आपकी पर्सनल डिटेल्स, आपकी जो इमिग्रेशन स्टेटस वगैरह है ना, उसकी डिटेल लेके तो मैं आपको बता दूंगा कि आपकी स्पेसिफिक केस में ये क्या पोजीशन है। लेकिन जनरली स्पीकिंग कोई भी ऑफेंस होना, अगर ड्राइविंग या क्रिमिनल केस, ये सब आपको डिक्लेयर करना पड़ेगा जिस वक्त आप
और वो लोग मुझे इंडेफिनिट तो देंगे ना, तो स्टॉप कर देंगे?
जी, आप अभी इंडेफिनिट पर है या आपका वीज़ा है?
वीज़ा इंडेफिनिट के लिए अप्लाई होने वाला हूँ जनवरी में।
जी, तो ये हो सकता है कि आपको थोड़ा इंतज़ार करना पड़े। इस ऑफेंस को थोड़ा पुराना हो ना, तो फिर उसके बाद जो है ना आपको एप्लीकेशन करना पड़ेगा ना, ठीक है। तो ये जो है नेशनलिटी के लिए अफेक्ट होगा, लेकिन इंडेफिनिट लीव टू रिमेन जो है ना आपकी हो जाएगी। जी
हो जाएगी
जी
इंशाल्लाह।
जी इंशाल्लाह।
जी कोई नहीं, मैं आपसे रब्ता कर लूँगा इंशाल्लाह। मैं आपका नंबर ले ले रहा हूँ
जी इंशाल्लाह।
और आपको मैं कांटेक्ट करूँगा। जज़ाकल्लाह।
जी जज़ाकल्लाह। अस्सलाम वालेकुम। We have another caller coming through. Assalamu alaikum.
Walaikum salam. Hello.
Hello, assalamu alaikum.
Walaikum salam. I just have a quick question about currently under bail under electronic tag, and I was just wondering under what scenarios and emergency scenarios would I be able to breach my bail? For example, if I had an emergency with my children who are in a different house, or if I had an emergency with the gas and electric, would I be able to breach that bail condition?
Look, generally speaking, there's no reason for you to breach your curfew. The reason the curfew is there is in order to keep a tag of you where you are. There's no reason at all where you can breach that like you're putting it. But there is circumstances in which you can contact the tagging company and inform them, look, there's emergency with your child, if there is, like you're saying, and then on a case-by-case basis, they'll have a look at the circumstances and then they'll advise you, and whether or not they decide to initiate proceedings against you is a matter for the tagging company and nobody else. To be honest with you, the advice will always be to keep to the tag and abide by it. The reason why it's there in place is in order for you to remain indoors between usually 7 to 7, and if there is any circumstances, the only thing you can do is notify the electronic tag monitoring company, and also contact the police, ring them on 101, notify them of the emergency, contact your solicitor, and contact as many departments as you can to notify them that this is the emergency, which shall be used by your solicitor in due course if you are breached.
Right. Thank you so much for that. That's actually helped me a lot.
No problem. Thank you. Assalamu alaikum.
What?
Now, we'll just move back to the caution. I was explaining the caution. So ordinarily, there's 3 separate times where you'll be cautioned for the offence: upon the arrest, upon getting booked in to police custody, and finally during the police interview. And at all times you'll be read out the caution, and at all times you'll be asked whether or not you understand the caution. The caution will be broken down to you in 3 parts, like I've explained to you, and then thereafter whatever you say or do will be recorded, and then a decision will be made at a later date whether or not any adverse inferences will be drawn against you, either to corroborate what you said or to go against you. We're just going to go on a short break, and I'll meet you after the break.